As he said, this was a textbook example of an agency overstepping its statutory authority to enact a requirement that Congress had not intended.
A judge provides temporary relief for the U.S. Conference of Catholic Bishops, several other Catholic organizations, and the states of Mississippi and Louisiana from having to comply with the federal agency's abortion mandate. In just a week from when we first brought you this story, a judge blocked the regulation by the Equal Employment Opportunity Commission that would have forced the USCCB and others to support employee abortions against their religious beliefs or state laws. The regulations of the EEOC issued in April and which took effect this week were added to the Pregnancy Workers Fairness Act. Federal Judge David Joseph said in his order, quote, if Congress had intended to mandate that employers accommodate elective abortions under the Pregnancy Workers Fairness Act, it would have spoken clearly when enacting the statute. For now, the mandate is paused while the legal challenge plays out. The judge's decision this week comes after a similar lawsuit filed by 17 states against the EEOC for the same abortion mandate was dismissed. On Monday, a judge in Kentucky blocked the Biden administration's rewrite of Title IX. The rewrite, which sparked lawsuits from more than 20 states, expands the definition of protected class to include gender identities. It is yet another mandate implemented by a government agency, in this case, the Department of Education, without any congressional action.
So the Biden administration is attempting to redefine sex in Title IX to include gender identity, which would gut women's equal opportunities. It would threaten their safety and their fairness. It would open up restrooms, locker rooms, even hotels on overnight stays to males who identify as females.
Alliance Defending Freedom has joined several states in their lawsuits challenging the Title IX rewrite. Judges granted preliminary injunctions in 2 of the cases, which represent 10 states highlighted right there on your screen. Tennessee, Louisiana, and Montana, just to name a few, will not have to comply with the law, which takes effect on August 1st. However, that may change when a ruling comes down.